Start it. Let me start.
Yeah, please. Yeah, please. Once we come into the class, learn something. Right? Yes. Yesterday we have seen different kinds of awards. We have seen final award, interim award, partial award, additional awards. Right? Yes. Default awards. We have seen different kinds of awards. Right? So today once an award has been passed, or what the award passed, it is having a what is called binding effect on the parties. ஒரு வாட்டி award pass ஆச்சுன்னா என்ன நடக்கும்? Whether you like the award or not, you have to follow. Why? You yourselves has accepted, consented that you are going before the arbitration, right? For class before arbitration, there is one clause is there that the award is final and binding on you, right? Now, assume that if you are not what is called accepting for the finality of the award, మీకు award ఒకవేళ మీరు అనుకున్న disputes settle చేయలేదు, if you think that certain claims have been omitted by the award, then you have certainly have a recourse. Recourse means you can turn back, you can go to the courts and you can set aside the awards. Right? You know, domestic awards will be there, foreign awards will be there, international commercial awards also will be there. So different types of awards will be there. Right? Now you are having some recourse against the awards. For example, in a civil court, if you get a decree and judgment which you feel aggrieved, what is the recourse? You can go for first appeal. First appeal to follow. Adhe madri, if you have any grievance over the award, then you have two options, right? We are going to see how it is challenged in the domestic courts. Domestic courts, the domestic arbitration, international commercial arbitration courts, adi ela untundi. First one, right? In the what is called arbitration agreement itself, you have outstanding jurisdiction. Another arbitration agreement you can select the jurisdiction. Dispute is somewhere, you can select the jurisdiction. Now, when you are challenging the award, right? Here you cannot oust the jurisdiction. design one, not projector on. Yeah. No, the choice is yours. Whether you want to complete the class early or I will start the class this month last. Yes. If you show it with choice only I can try, I will tell some special class they need. I have not completed my syllabus. I will try to this next month will be Origo Max class. Where are finish చేస్తున్నామా in time లో finish ప్రాక్టీస్ క్లాస్ తో వై ఎందుకో నేను చేస్తా I will tell that my syllabus is not completed and I will drag the class another 15 days. Right? Yeah. Right. Yes. So, whenever you are unwilling to accept the award, you have two choices. You want the award passed on out, no doubt, it is what's your name? What's your name? Huh? What's your name? No, no, there is an etiquette attached to the class. Whoever is named. Huh? Your class won't work. Once you come into the class, don't think that it will be left alone. If I become outrageous, there will be something different for you. My students will know about this. When the class begins, all the girls in room number one. You want to tell your option is always open there for you. Sit there, sit in the room number 4-1. Whoever sits in room number 4-1, they will be getting 6 days 5 off. Sit there. 6 days 5 off, you are going to face it. That don't think that. Right? No, you are paying such a huge amount. Cinema ticket cinema full. You are paying such a huge amount here. So you don't know. Last batch is very good batch. I am proud to say this batch only a handful of people are able to understand the intricacies of law. Subhanallah, didn't just well. At least listen something. These last 20 days, listen something. At least get something. You are going into what is called next what life. Indoor class in 5 years, 3 years, last 20 days, at least listen something. Right? Yes. So, no, I don't want to hurt you. There is something attached to the class. Class is like institute is also like this. If you don't have that sort of obedience, remember, your life will be on the roads. The students who are obedient enough, they are going good. Who are what is called arrogance, literally, they are on the roads. I will tell you who is doing well in the course. I will tell you who are on the roads. I am proud to say some people call me today also, sir, because of you we are doing well. They are doing very good in big corporate firms. Rest of all the people are going just literally on the roads. Just decide, this is your life. You have every option to decide your life either this way or that way. ఇలానా వెళ్ళొచ్చు అలానా వెళ్ళొచ్చు ఎప్పుడైనా మనలాన్నా ప్రాబ్లం கிடையாது இப்படிதான் இருக்கணும் லைஃப் வந்தா then you have to face a lot of things in your life. Please listen. Once you come into the class, please listen. Still, you are in the arithmetical stage, small kids. You don't know the intricacies of law. I don't know how many people know this. How there is an array of things. Alternate remedies will be there. So many things will be there. Once if you come into the class, shut the cell phones. I am coming. Everybody, even everybody are pagaldilla. All engrossed in mobile phones. We can live without your father. We can live without your mother. We can live without your husband. We can live without your wife. We can live without your children. But you can't live without your mobile phone. Right? Keep the mobile phones like this. That's what I am telling. Addiction, anything, addiction which is bad, you need not smoke and drink. Cell phone is enough to spoil your life. நீங்க தண்ணி அடிச்சு ஸ்மோக் பண்ணி ஹெல்த் அப்செட் பண்ணிக்கிற தேவையில்லை. செல்போன் ஒன்று இருந்தா போதும். You will become lethargic and you will become indisciplined. Right? One mark on 6 days వరకు వెళ్తే అప్పుడు తెలుస్తుంది 6 days. Right? ఏం నీకే ఆ రోజు నా వైపు right? Oh, once if you come in the class, listen something. Am I telling something? No, I am telling exact thing. If I tell something also, you will listen. If I tell anything also, you will listen. If I tell nothing also, you will listen. But I am not telling, I am telling the exact things. Try to learn some new technicalities of law. Law on the just all India bar exam எழுதி enroll பண்ணி ஒரு செல்ஃபி எடுத்து ropes one selfie, put it in the status. That is the first and last status. That's first status. That's last status. Your honeymoon is only for 1 day. Honeymoon for 1 week or 1 month. Once you wear that robe, your honeymoon is for only 1 or 2 days. Then problems then starts. Right? Don't be like that. Every day is it's called learning day for you. Putting it up, listen something, right? So, whether it is a domestic arbitration or international commercial arbitration, whatever it may be, domestic arbitration you know, international commercial arbitration also you are going, right? Under UN Central Model Law, it has been governed by the United Nations Commission on International Trade Law. Even in international trade law, UN Central Model will come. You are signatories to UN Central Model Law. So, domestic agreement agreements, whatever it may be, when you are going for foreign awards also, you can what is called get a recourse in 2 stages. ஒன்று என்ன நடக்கும்னா அவார்டே வாங்கலாம்னு சொல்லி கோர்ட்டுக்கு போய் செட் அசைட் பண்ணலாம். First straight away you are challenging the award itself, setting aside the award. Otherwise, you are keeping quiet when the award has been what is called given in the course for enforcement. At the stage also, you can have your recourse. 2 recourse ஒன்று அவார்ட் கொடுத்த உடனே கோர்ட்டுக்கு போய் செட் அசைட் பண்ணலாம் அவார்ட். இல்ல அவார்ட் கொடுத்தா only keep quiet when it has been what is called filing the court for enforcement, then you can raise some objections. 2 types you can challenge. Straight away decree and judgment என்ன பண்ணலாம், நீ அப்பீல் போய் சேலஞ்ச் பண்ணலாம். இல்ல decree and judgment execution file பண்ண போது கூட நீங்க என்ன பண்ணலாம், you can raise objections. You understand? Straight away you can challenge the decree and judgment by way of an appeal or keep quiet. When it has been filed for execution, you can raise objection. Execution என்ன நடக்கும் தெரியுமா? Same procedure will come. Suit எப்படி இருக்குமோ EP ல கூட அதே summons issue பேசினாலோ in execution petition you can raise objections with respect to validity of the interim judgment. You can raise the objections in EP also. You can go for appeal or you can raise objections in execution petition. Likewise, you can straight away go and set aside for award, or while the award has been executed at that time, you can put forth your arguments 2 times. So, in a domestic or international commercial arbitration under Part 1 of Arbitration Conciliation Act, if a party seeks to avoid an award, right, again, you cannot challenge on whatever be the grounds. There are very restricted grounds available to set aside the award. Even Supreme Court cannot reverse the award. Very limited grounds, right? So there are limited grounds under which the party can do so. If dissatisfied with an award, right? If you are not satisfied with the award and unwilling to voluntarily accept its effect, that means binding effect, an unsuccessful party has 2 options. Two options will right? We will see what it is. 2 things: domestic, international. Both you are accepting the awards. Domestic awards will accept చేస్తున్నారు. International commercial arbitration. 2 companies are there. They are going for an arbitration. You are recognizing the award because you are signatories to US intermodal law. You are means not you, India. India is signatory, right? For example, prevention of money laundering acts is there. You know the meaning of prevention of money laundering acts. Karima, Kariya. Once if you book it under prevention of money laundering act, there is no bail for you. They are known as economic offences. Economic offences, right? Under this also, financial action task force is there. FATF. You are signatories to FATF. So many things will come, right? If it is a domestic or international commercial arbitration, right? If it is a domestic or international commercial arbitration, challenge the award for setting aside. You are challenging the award for setting aside the award, right? Inappropriate, where you are going and filing civil courts, right? Appropriate civil court having jurisdiction over the matter. For example, you have entered into contract in Tirupati, your arbitration has been sent in Chennai, award has been passed in Bangalore. Then, which court is having jurisdiction? Bangalore court is having jurisdiction. Award ఎక్కడ పాస్ చేస్తారో ఆ ప్లేస్ లో అక్కడ ఉండే కోర్టుకి jurisdiction వస్తుంది. మీరు అక్కడ ఛాలెంజ్ చేయాలి. That jurisdiction you cannot oust by your consent. Ikkademo you can oust by your consent. But once that's for award should contain place, date, seat of arbitration. That implies that you are going in that jurisdiction and challenging the awards. So if it is a domestic or international commercial arbitration, challenge the award both domestic or international commercial ఏదన్నా కూడా ఎక్కడ వెళ్ళి ఛాలెంజ్ చేయాలి సివిల్ కోర్ట్ having jurisdiction over the matter civil court exercising original jurisdiction. Right. Now, in international commercial arbitration, if a party choose not to challenge the award in India, if the party chooses, in the challenge, decide wait. ఎప్పటివరకు wait for execution we have to wait. So in India, under section 34, wait until the successful party initiates enforcement proceedings. That means execution proceedings before a court in the state of enforcement and at the state seek to resist enforcement. So two ways you have recourse to arbitral award. One is straight away you are going to the civil court and filing an application for setting aside the award. Or wait, other party is going to enforce the award. At that time you are going and raising the objections. Award set aside ஆச்சுன்னா அப்புறம் அதுக்கு வந்து don't have the sanctity of the law. That means it becomes non-just in the eyes of the law. Award civil court பக்கத்துல வச்சிட்டு வெச்சுக்கோ. Award என்ன? In the eyes of the law it is not in existence. Non-just NONEST. Non-just in the eyes of the law. So two options: straight away go to civil court, challenge it, or international commercial arbitration, wait till the other party goes seeks to enforcement, then at that time to challenge the awards. Right. Now again, in majority of model law jurisdiction, challenge cannot and should not amount to a review of the merits of the award. To understand the legal terminology, challenge you should not consider it as a review of the award. You understand? Civil courts never interfere in the award or never modify the award, whether to set aside the award or simply disagree. After the review review means civil court cannot review the merits of the award and challenge the terms and conditions of the award. So you cannot take it as a review. Review, you know the meaning of review. The court which calls a decree and judgment, the court which calls it the order, it can review its own order, which it can modify the order. Here, when you are seeking the challenge, it does not amount to review of the order. Review ki edutho mudiyadhu. Yenna award vandu maatha mudiyadhu. Set aside pannuvom avladha. But terms and conditions alla maathuvamna even avangalukku kuda power kadayadu. So majority of model law jurisdictions, a challenge cannot and should not amount to a review of the merits of the award. Right. Now we are going to see manner, place, and time limit of the challenge. How you are going? What is the manner, place, time limit of challenging the awards? Right. So according to section 34, you are going in setting aside the award. Under section 34, you are going to the court, filing the petition for setting aside the awards. Right. Parties have to make an application for setting aside an award before a competent court having jurisdiction to hear an application. So you have to go to the appropriate civil court having jurisdiction over the matter, file an application under section 34 for setting aside the award. Also, an application for setting aside may not be made after 3 months. That means within 3 months you have to file an application for setting aside the award. Again, Arbitration Conciliation Act is a special law which binds even against Arbitration Act. So Arbitration Conciliation Act எவ்வளவு time limit சொல்லிருக்கோம் அதெல்லாம் நீங்க ஃபாலோ பண்ணணும். What is the time limit? May not be made after 3 months have elapsed from the date on which the party making that application had received the arbitral award within 3 months of receiving the award. Not passing the award within 3 months of receiving the award, or if a request has been made under section 33 of the Arbitration and Conciliation Act from the date on which that request has been disposed of by the tribunal. If you are making a request to the tribunal, unlimited time 3 months, you have to go on, file and set aside application under later section 33 or 34. Depends upon the things. Right. However, so far as application for making or setting aside the award is concerned, the period of limitation has been prescribed in section 34(3) of the Arbitration Conciliation Act is 3 months, right? 3 months, but it can be extended for another period of 30 days on sufficient cause being shown to the satisfaction of the court. 3 months local you have to file an application for setting aside the award. If within 3 months you are unable to file an application for setting aside the award, with the permission of the court, it can be extended to another 30 days. 30 days. இதுக்கு மேல வராது limitation not apply or whatever be the time prescribed under the Arbitration Conciliation Act, it will apply. Right. Now, method of challenge. With the reference to the nature of the process and the manner dealing an application. Right. Now, judgment decree only if you are going for setting aside, and trials. You understand? To understand it, because if you are challenging the decree and judgment has been caused by following civil procedure code, by following law of evidence, by following any other applicable act. That means trial will be there. In the trials will come. Decree and judgment to pass on trials will come. Arbitration will come. Trials will come. First class itself I told you. There is no trials in the Arbitration Conciliation Act. Based upon the consent of the parties, based upon the agreement, based upon principles of natural justice, arbitrator is working. Right? Because you are going and filing an application for setting aside, then அது வந்து வெளியே ட்ரையல் கிடையாது. ஏன் ட்ரையல் இல்லாத பாஸ் ஆச்சு? This is very important. You say it is important to note that a proceeding under section 34 of the Arbitration Conciliation Act is not a regular civil trial. Civil trial மாதிரி திருப்பியும் notice எல்லாம் கொடுத்து திருப்பியும் ஒரு they don't conduct proceedings. You understand why? Earlier proceedings also don't have any trial. Decree and judgment appeal போறதுக்கு என்ன இருக்கும்? Trials இருக்கும். First appeal, they can reverse your judgment. First appeal. Second appeal, you know on what ground second appeal is filed. Huh? You know the decree and judgment. First appeal, second appeal. Right. On what grounds your second appeal is entertained by the courts? ఏం రాజా నాయుడు తెలియదు తెలిస్తేనే ప్రాబ్లం தெரிஞ்சானா ప్రాబ్లం தெரியலன்னா ప్రాబ్లమే இல்ல సైకిల్ ఉంటే ప్రాబ్లం సైకిల్ సాటిస్ఫై అయితే ప్రాబ్లం లా வண்டி ஓனன்னா ప్రాబ్లం స్టార్ట్స్ வண்டி இருந்து ஓகே அண்ணா ప్రాబ్లం இல்ல கார் ஓனன்னா ప్రాబ్లం స్టార్ట్స్ సో ஒன்னோட சாட்டிஸ்ஃபை ஆனா ప్రాబ్లం இல்ல இன்னொரு ஓனன்னா ప్రాబ్లం స్టార్ట్స్ సో రెండు இருந்தா ప్రాబ్లం స్టార్ట్స్ understand yeah problem right second appeal location na புரியல ரெண்டு என்ன ரெண்டு அம்பிராஜ் செகண்ட் அப்பீல் ஆன்சர் சொன்னானா Y wala pass illanna pass right no you understand if you go to the court whatever be the petitions filed they don't take second of the entertain panadonna first enna irukku substantial questions of law unless and until you satisfy substantial questions of law నువ్వు రేపు నుంచి టైంకి రాలేదంటే స్టాండ్ చేయాలి అర్థమైందా రైట్ నేను చూడకూడదు లేట్కి వస్తే నువ్వు వాడు గౌతమ్ కదా వాడు రైట్ రైట్ వాడు మంచోడు రైట్ సబ్స్టాన్షియల్ క్వశ్చన్స్ ఆఫ్ లా రైట్ unless and until you satisfy the court substantial questions of law your second appeal won't be entertained first aspect ఇక్కడ కూడా ఏం జరుగుతా ఉంది అంటే the court is not conducting any trial again why previously no CPC no evidence now I am not going to entertain why if I adopt CPC evidence the earlier trial will go on right so it is not a regular civil trial regular civil trial kadiyadu idu setting aside an award you understand court ke elite regular trial untundi procedure will be there before arbitrator the main advantage is arbitrator is not following the regular court procedure simply within 3-4 months or the time agreed by the parties he is passing an award right so although an applicant under section 34 is interested in getting an order setting aside an award his opponent is equally interested in ensuring that it is not set aside he set aside போல அவன் என்ன பண்ணுவான் பண்ண கூடாதுன்னு சொல்லுவான் understand because award is in his favor when two persons are going and challenging the Indian judgment you are interested other person is not interested why it is in his favor like now but upheld accordingly present their case to the judge to prove their point right now the award has been passed by a private consensual and non-adversarial you understand consensual and non-adversarial that means they are not adjudicating your dispute now you are going and challenging the award setting aside the award to some extent it is adversarial judge enna pannuvaarna he will follow certain law that means he is adjudicating your dispute now புரியுதா இப்ப என்ன பண்ணுவான் ஜட்ஜ் செட் அசைட் பண்ணலாம் பண்ணாதையும் போலாம் that means he is adjudicating on the merits of the case at any point of time you may be aggrieved by that right an application under section 34 instance do have some character of adversarial process setting aside பண்ணும்போது மாத்திரம் நீ எங்க வந்திருக்க இப்போ regular court க்கு வந்திருக்க it came to the courts that means courts has to follow law follow பண்ணா என்ன பண்ணுவோம் award set aside பண்ணுவ law follow చేసి ఏం చేస్తావు set aside చేస్తావు you understand normal courts are always having this adversarial process for example two persons go to the court one person favor and 10% cannot go adverse ஆக இருக்கும் right that means புடிச்சாலும் புடிக்கலனாலும் அது process ఇక్కడ కూడా ఏం జరుగుతా ఉంది అంటే private arbitrator is passing an award court following any process now you came to the court for setting aside the award it is some sense adversarial from any trial kadiyadu but definitely I am going to adjudicate on the merits of the case That is private arbitrator. But you are come to the court, civil courts. Civil court is having jurisdiction over every matter. Yes, unless and until it is statute part section 9 of civil code. If you see section 9, civil code எல்லாத்துக்கும் jurisdiction இருக்கும். By either expressly or impliedly called by any other statute. For example, insolvency bankruptcy code is that tells civil code don't have jurisdiction. That means expressly civil code jurisdiction is barred. Right? So, in that sense, do have some character of Sharma. No, why this sort of addiction is there for you? You can't even listen for 2-3 minutes. Your focus has been deviated. Without focus, you cannot do this is a profession which is having two extremes. Either stand at the lower level or go at the higher level. There is no middle level in this profession. Irunda, அந்த level இல்லன்னா இல்ல. Middle level in the function கிடையாது. To understand, it requires lot of physical and mental what is called capacity and caliber. Simply one, you are thinking that once you can go to the course, you know law. 20-30 years also you don't know anything. With this attitude, I am what is called you are a grown up child, you have to know certain things. Right. Now, have some character of adversarial process, but proceedings under section 34 differ from regular civil suits. Regular civil suits are irregular, but to some extent it is there. Right? For example, an application under section 34 of the Act is a single issue proceeding where the place. The very fact that application has been instituted under that particular provision declares the issue involved. Right? The framing of issues are like civil suit, there will be framing of issues. Now, any further exercise to frame issues will only delay the proceeding. Civil suit, you know, all issues are framed. All the issues only the court will adjudicate. Ikkada only framing of issues ante undadu. Why means delay will happen here. Right? It is thus clear that issues need not be framed in applications under section 34 of the Act. Civil suit மாதிரி issues frame பண்ற தேவை கிடையாது. Even if you go to first appeal, second appeal, also court will frame certain issues. Here, there is no such framing of issues will be there. Right? Now, also in the regular civil suit, in the event of failure to file a defense means written statement. If you fail to file a written statement, it will be lawful for the court to pronounce the judgment on the basis of facts contained in the plaint. Written statement file பண்றதுக்கு முன்ன கூட ஜட்ஜ்மென்ட் கொடுக்கலாம் கோர்ட் தெரியுமா உங்களுக்கு clear even before filing the written that is judgment before filing the counter also they can give judgments first time la kuda once you file the plaint the court may pronounce judgment at once hearing the statement provisions of the CPC inga kuda enna nadakumna you say in the regular civil suit normal civil suit la written statement file பண்றாங்க court என்ன பண்ணும் judgment will be pronounced in the regular civil suit in the event of a failure to file a defense it will be lawful for the court to pronounce the judgment on the basis of facts contained in the claim. For sleep, there is still time is there. After 3 minutes, you can have CBC enter in your head and sleep. You have two options. If you want to know the subject, see, read. Right. That is first option. Second option, you go to a shop. You go to a shop. Which app you want to be expertise? Purchase that book. And book என்ன பண்ணுங்க? First வாங்கிக்கணும். Again go to provision store. Bring one mixie. Book on mixie la போட்டு put some water. Stir mixie la వేసి drink. Then you will become expert. Yeah. எனக்கு ஏதாவது எக்ஸ்பர்டைஸ் பண்ணணும்னா நான் மிக்ஸில போட்டு சாப்பிடணும். ரைட். என்ன தெரியும் பாவமா இல்லையா? ரைட். In an application under section 34, right, even if there is no contest, the court cannot, on the basis of the arguments contained in the application, set aside the above. Right? Even if there is no contest, the court cannot set aside the above. And the contest is another one. Exported by cross order. Whether there is contest or not, the applicant has to prove one of the grounds set out in section 34. Section 34 grounds இருக்கும். அதை நீ prove பண்ணானா set aside. இல்லன்னா set aside முடியாது. சிவில் கோர்ட்ல வந்து written statement ஃபைல் பண்ணலன்னா எக்ஸ்போர்ட்டிங் எல்லாம் கிடையாது. Whether there is contest or not, you have to prove the grounds that has been prescribed under section 34. Right. Something went into your mind. You have to put your mind there. என்ன போச்சா? ஏரியா போச்சா? நான் வெளில போனவனே again leave this from this campus. Right. Next class என்ன? என்னது? சார் பேர் என்ன? தெரியுமா? யார் பேர் தெரியுமா? Very good. Right. Yeah. Again, fourth hour I am coming on the insolvency language. Fourth. There is no such law that general population చెప్పడం ఏదైనా చట్టం ఉంటుందా మీకు ఏదైనా చెప్పే చట్టం ఏదైనా లా இருக்கா உங்களுக்கு applicable ஆகாத లా இருக்கா simply you will tell sir we are general we don't have insolvency and bankruptcy laws. What is this thing? I don't understand. For any advocate there is no law applicable to him. Listen, if you want to become a corporate advocate, you have to learn insolvency and bankruptcy. Companies Act along twice before. There is no Companies Act we have now. Only option that's for you to do insolvency bankruptcy laws. Right? Now see both. Okay. Those who have not visited, please leave the class as soon as possible. Now, okay, rest of us, please wrap it up. Today we are going to discuss about what the main function of the police department, that is arrest. What do you mean by the term when you call arrest? What does it mean? Yes. Basically, if we say it, arrest means to take out the liberty, right of liberty of a person by the state. Yes or no? So, arrest most probably not defined in either any of the in CRPC and any other law for time being in force. But the provision of arrest is given in different case laws, so also in the provisions of the CRPC and all others act. So arrest basically comes from a French word arresteur, that means to stop or to apprehend, and from there we can derive our definition of arrest. That means we apprehend, we stop, we take out a kind of liberty of a person by a authorized and here that means as a layman, as a general public, can we arrest a person? You, me, can we arrest? Where is the position? So, if you go to section 44 of the CRPC, there you can find out the provision where a general public can also arrest the person in two conditions when the offense committed by that person is a not valuable one and a obvious one, then the procedure is to take that person. If you like a general public like you and me arrested a person, if we have to take that person to the nearest police station or to hand over that person to the police officer present at that time. That is the procedure given under section 44. Here, mostly the arrest is done by the police. Yes or no? Why it is done? What is the purpose of arrest? Hmm? Yes. Basically, not to flee from the justice or to take that person before the court or justice. That is the one of the purpose. That means it is securing the attendance of the accused at a trial. Second one, as a preventive measure, starting from your 109, 110, 111, preventive measures that are there, where before any kind of festivals, the crafts are anti-socials, so they cannot disturb the general public. As a preventive action, obtaining the correct name and address of the person. Section 42. Section 42 says that though that person committed a non-cognizable offense, still if that person is not giving his correct address or correct name, in that case, police can arrest that particular person. Myself, so I am not giving the proper name to the police, though I am committing a non-cognizable offense. So, obviously, if it is a non-cognizable offense, police need a warrant or an order from the court. So, without that warrant, I am saying that I am Sachin Tendulkar. When he is asking my name, instead of saying that my name is Romasko, I am saying that my name is Sachin Tendulkar. I am staying in the Andhra, Mumbai. So, in that case, they can arrest me to collect my proper address and name. Then what I told you, if you go to section 42 of CRPC, 42 of CRPC says that arrest can be done in two ways, with warrant, without warrant. Section 41 says that without warrant it can be arrested. The circumstances are given. For non-cognizable offense, you need a warrant. That means you need a order from the court to arrest a person who committed a non-cognizable offense. But in those cases, section 42 says that if that person who committed a non-cognizable case, offense, in that case, if that person is not giving his correct name or address, in that case, police can arrest him. Let it is a common practice in India that if it is not in favor, any order, any judgment, or any uh, direction given by the government and which is not favorable to us as a general public, we go for a hartal, right? Hartal, you know, strike. And police come there to remove that obstructions because we make a barricade and sit there. And no doubt, when you are disturbing the public, it is a nuisance and it is arrestable. Offensive, sorry, offensive. But when police came and he tried to remove that obstructions, he tried to remove you, and you are obstructing that thing, that is also punishment. Yes, if you find out that during the strike they stop the train, highways and all that, those who are there at the present at the time, those who are informed for stopping of the train, highway or any other thing, a charge is framed against them. Last one, for retaking the person escaped from the custody. So the section 41, 42, 151 given different circumstances where a police officer can arrest Yes or no? But question is how that arrest is happened. What is the procedure of that arrest? Huh? Go handcuff that person, put it in the car, take it. Like that? I committed an offense. I committed an illegal act. How the police is going to arrest me? Like in the films, they show that some people come out of the vehicles, they grab that person, handcuff that person, throw in the car or vehicle, take him to the jail like that. Huh? But it is not the procedure. Where the procedure is given, 46 of CRPC. Huh? Arrest how made. That is the actually the procedure. After that section also there are two famous cases where the guidelines are given how to make an arrest. During arrest, what is the duty of the police officer to do that arrest, and what is the right of that person, that means the arrested person after the arrest. All that things are said in this first case is Joginder Kumar case, second one is your T.K. Vasu. Yes. T.K. Vasu versus State of West Bengal 1997 or sometime. Vasu. So mostly the whatever the guidelines are there after 2009 amendment of CRPC, you can find out in sections like 41A, 41B, 41C, 41D, and all other amendments which is happened after that. First one is guidelines laid down in the Joginder Kumar case. That person who is held in the custody is entitled that he can give or the police need to give the news of arrest to a person of his acquaintance. That means to his friend or family members should know that their persons are arrested, is arrested by the police. If you are arrested, it is the duty of the police officer to give that news that you are being arrested by them to your family members or to your friends. The police officers will inform the arrested person when he brought to the police station of this right. That means whatever the rights are there for him, it should be clearly explained to the arrested person. Third one, the entries shall be required to be made in the diary as to who was informed of the arrest. Like your in CRPC, it is called arrest memo. To whom you are arrested, by whom that arrest was made, to whom the news of arrest or information regarding that person's arrest is given. That memo was done by the police. Last one, it shall be the duty of the magistrate before whom the arrested person is produced to satisfy himself that these requirements have been complied with Indian canons. That means judge need to confirm that all the procedures are complied with when a person get arrested. Same thing in 1997 T.K. Vasu versus State of West Bengal case laid down certain guidelines. What is to be done by the police? Sorry, during the arrest, after arrest, all the guidelines are given in this case. What are the guidelines? First one, the person who made the arrest, that means that police officer, wear a clear name tag and his position indication. Yes. So from which you can say that this station IIC Mr. This X arrested me or not. So because most of the time you can saw that people police come in the civilians and they make arrest. To avoid that thing, they should clearly hear the correct address. Good morning, students. On behalf of all students, so today for observation for 3 years children, register number 522301 up to 50 morning session. For there, kindly by room number 44. And afternoon session 51 to 100. 3 years children 51 to 100. You come after today afternoon session. At the same time, actual schedule for second today, 3 years smaller students 5224 up to 250 now morning session. So harder students, if anybody is with this register number, you can go for room number 44. And afternoon batch 5224 51 up to 302. You come for afternoon session today afternoon. At the same time, 3 years general up to 51 to up to 100 you come afternoon. And yesterday BB and BCom students, if anyone not receive the messages, you can come today morning session. If any absentees there. Absentees for yesterday you came here but you don't know information, you should come for today's session. And another announcements, your child visit we are discussing to the prison authorities, they will inform later. Okay? Jail visits, we will inform later when is the exact schedule. So kindly note it for your police station observation 6 and 8. In Tiruchanur police station, you know for Tiruchanur? Tiruchanur police station, we are conducting for police station visits. So on 6th onwards, 3-year Ll.B and 5-year B.A. and 5-year B.B. So 3 years general and B.A. and B.B. on the schedule for 6th. At sharp 9:30 in Tiruchanur police station. Okay? So 9:30 you should be present at Tiruchanur police station. 3 years general students and BA and BBA students. No, for all. 3 years general course students for all students and BA general all students and BBA students for all students. You can come for Tiruchanur police station for your police station visit. Yes, directly after come to the Tiruchanur police station. And 8th onwards. Only for morning session. 9:30 to 11 o'clock. Okay? After police station visit over, we will inform what will happen. Actually, we have to plan some other program on the day. We will say at the time. Okay, anyway, 11 o'clock your visit will be over. So 9:30 to 11 o'clock, come and don't bring your vehicle in the near police station. It's very rushy temple as well. Okay? But now the temple is there, so don't bring your car. And going onwards, 3 years Ll.B. honors students for all students, and 5-year BA Ll.B. honors and BCom Ll.B. students. So these 2 days only we have getting the permission for this sort of police station, police visits. I am instructing all the students must come the proper dress codes. Okay? Like that somebody is came for court, casual or wearing some other shoe strictly prohibited in police station. So come proper dress code. And don't bring your vehicle in near police station. And another thing, uh, 30th schedule. As per 3 is honor students. 1 to 50 and 51 to 100 you have scheduled for tomorrow in court visit. And 23 afternoon batch you have for again post visit. 251 to 303 general students. Thank you. Actually, RA students, how many are RA students is there? RA students is there come tomorrow afternoon for arrears past students. This semester means okay, RA students you can come tomorrow afternoon session. Okay, thank you. Okay, listen. Silence. So here in the case of JK also case, first one is when the police officer is arresting that person, that police officer should clearly wear a name tag, his identification, all that things. Second one, second one regarding the interrogation. Like in the films, it is not that anybody can enter to the interrogation room and start to interrogate. No. They need to follow the procedure. That means if they need to interrogate a person, they need to make a entry on their book that okay, SI or IIC, OIC interrogate to Mr. X who is charged with under this sections. They need to enter the form there. Or there is a book, they need to enter it. Third one, as I told you, there must be a arrest memo. That means the person who is arresting, the person to whom they make the arrest, some as a witness, respectable persons from that locality need to be signed in that memo. Okay, we are arresting this person from this particular place. This is the person who is arrested. This is the officer who made the arrest, and these are the witnesses. Two or three witnesses they need to be signed there. And there also time, place of arrest, value of the custody of the arrestee must be notified by the police to the next friend. Family member or friends are there. From where you are arresting that person, where you are keeping that person after the arrest, that need to be informed. After arrest, that person need to be go through a medical examination. You are under section 51. Sorry, not 51. 53 or 54 something. 53 basically. So there, arrested person need to be go through a medical examination that is there any mark, injury or anything is there or not for that need. That memo should be signed by both arrestee and the police officer. Medical examination should be done in every 48 hours while that person is in the custody. Copies of the all document including the memo of arrest record to the above sent to the concerned magistrate for this record. That means there is a procedure that under section 57 that you need to produce the arrested person before the nearest magistrate. So when you are producing that arrested person, you need to produce all the concerned document regarding his arrest. Arrestee have the permission to meet with his legal representative or advocate during the interrogation. And after that, via 41C, there must be a police control room should be provided in all the district and state headquarters to display the particulars of arrestees on the conspicuous notice board. You have the court where, sorry, police station, you can find out a notice board. On this particular date, who are arrested, when they get arrested. Otherwise, not a police officer. Court visit, jail visit, police station visit, everything can be happened. In single time. Yes, sir. Supreme Court, though it is handled as original jurisdiction, but it is for specific cases. Supreme Court is Supreme Court. If we go for a 90 cases for that thing or 50 cases for the Supreme Court, it is not a good idea. It is the misusing of the time of the Supreme Court. That's all. So there are other courts are there, lower courts are there, where the small cases can be adjudicated. In some cases, there is special invitations and all that things are there, or the violation of their fundamental rights under Article 32, you can directly approach to the Supreme Court. But in certain cases, limited cases, not in all cases, then only you can approach the Supreme Court directly, not all. Now come to the provision, case law is over. Come to the provision, section 46. Procedure of arrest, or the headline of the section 46 says that how arrest made, like that. Yes. You are ready to- yeah, so what- don't worry, Okay. First thing, if a police officer comes to you to arrest you, that is the first point. That means you shall have to submit yourself to the custody of the police. If you are not, in that case, police can use all the powers to make them arrest. Third one, if you are charged under a offense where there is a death sentence or life imprisonment, in that case, if you are trying to escape from the custody of the police or you are trying to avoid the arrest, in that case, they can cause the death of not suicide. It is the last one. Suicide is something different from this one. Okay. So basically, under section 46 it says that when you are charged under the offense, then there is a punishment is death sentence or life imprisonment. In that case, you are trying to avoid the arrest or you are trying to escape from the custody of the police. In that case, it can cause the death, but it is not the first option. It should be the last option for the police, not for you. He cannot directly charge you for the murder and take out gun and shoot you. No, they cannot. There is the code of conduct of the procedures are given that how that police is going to arrest you in that cases. That means in police act you can find it out. And here also it is says in different case laws are also says that to kill someone, to cause the death of someone, it should always an exceptional cases, not in the general. Yes, sometimes there is a thin line difference between extrajudicial killing and this thing. Some, I think last year in Hyderabad, Odisha case or in Hyderabad, Disha. So there the Hyderabad police shoot that person, encounter that person, and he want to try to escape from the police custody. Minor also in our place also there is a person they try to escape and kill. Can a police officer arrest a woman? So a woman upon the oral intimation of an arrest shall presume to have submitted herself before the arresting officer and as such she cannot be touched unless and until circumstances force to do that thing. After that, if it is needed to be arrested a woman, there must be a woman police officer should be there to arrest that lady. After that also one another condition is there. After sunset and before sunrise, a woman cannot be arrested unless and until there is an exceptional circumstances. If there is an exceptional circumstances, no, it is not only about a woman police officer. A prior order should be taken from the JMFC, Judicial Magistrate First Class, and along with that order, a lady police officer should be present while arrested is happened. That means after sunset and before sunrise. Before sunrise. Right of the arrested person. What are the rights of the arrested person according to you? First thing is you need your information regarding your arrest. Right to know the grounds of your arrest. But right now, if you ask that thing to a police officer, you get a free start pass. So you have a personal experience regarding that. First thing, need the person, arrested person has the right to know the grounds of the arrest. Second one, the information regarding bail. If the police officer arrested a person of an offense which is bailable in nature or non-bailable in nature, it should be information. This information should be given to that arrested person. Okay, boss, you are arrested for these offences and which is bailable. If it is bailable under 436 of CRPC, police can give the bail to that person. If it is a non-bailable offense, in that case, police should give regarding information should be given on that basis also that you need to consult with a advocate for that bill on that particular clear regarding bill. Okay, sorry to waste your time. I know that I know very little than you, but still you are in a class. Please maintain that decorum. I know that you know better than me, and that's why you are chit chatting among yourself. So, but unless and until you are in a class, please maintain that decorum. Clear? Thank you, sir. They are available, sir. There is no scarcity of doctors in our country. Don't worry about that. Next one, right to be produced within 24 hours before a magistrate. According to section 57 of CRPC, it says that if a person is arrested without a warrant, that means the circumstances which is given under section 41 of CRPC, if a person is arrested under that circumstances, you need to produce that person before the magistrate within 24 hours. But the problem is, what does it mean? That means you have to produce or you need to change the custody of the police, the arrested person from the police custody to the judicial custody. Once that person is inside the judicial custody, you cannot, the police officer cannot investigate further because unless and until he is in the police. So when a police officer need to, that means according to section 57, the police officer need to investigate within 24 hours. before handing over it to the judicial custody. But practically it is not possible to investigate any matter, even simply chappal chori case. So within 24 hours. So in that case, what is the procedure? In that case, when the investigation is not completed, practically everybody knows that it is not possible to complete the investigation within 24 hours. Yes, remand 167. Clear? That means with the permission of the court, you are taking the custody of the, not you are, the police taking the custody of that arrested person from the judicial custody to the police custody again, maximum for 15 days. Examination of the arrested person by a medical officer. In the Ikebasu case also we learned that thing. That means once that person is arrested under section 53, 54, 167, 167A, there are different sections are there where arrested persons, victims, offenders are need to be medically examined by a registered medical practitioner. Clear? It is his right to consult a legal practitioner. Many of the films you can see that before a arrest or while the person is going to be arrested, in that case the person says that I need to talk with my advocate. That right is given by section 51, 51A or 51 clause 1, something like that. Next one is doing the search and seizure. Search is can be done in two ways. One without warrant, second one with warrant. What can be done without warrant and what can be done with warrant? Let's discuss this. In tomorrow I die. In today I die. In that case, some other one is there to be not me. Huh? Few more minutes, don't worry about it. I'm not going to waste more of your time. Search without a warrant can be done in three circumstances: search of a person, search of a place, and search for things. First one, search of a person. Search of a person. Mostly, search of a person is conducted to a arrested person. Under section 51 and 52 is the procedure. So when a police officer arrested a person, they need to search him, whatever the belongings with that person, his mobile, his purse, his that pocket, all that things, they need to seize it. They need to make a list of that thing, and one copy is given to the arrested person, or on his request, it should be given to the next friend of that arrested person. First one. It is said in section 51. Section 52 says that when you are searching that particular arrested person, a weapon is seized from that person. Gun, chaku, bomb, whatever you can say. Huh? Knife. So in that case, they need to seize it. Need to make a separate memo for that thing, and they need to produce it before the magistrate. So, sir, when we are searching this person, we receive this weapon from this arrested one. If you need the pen you are getting is also a weapon. If you can use it. Search of a place. Search of a place basically is done when a police officer is apprehending a person or trying to catch a person is and he entered to a place. Whatever the circumstances is. As a police officer, I want to catch you. You are committed some offense which is come under the circumstances given under section 41 of CRPC or any other case. And you run away into a building and present or whatever it is, you enter in that place. Under section 47, I can search that place without warrant. In that case, whatever the 47 says, that person, the owner, the caretaker, or the person who is in the possession of that property, allow me to enter to that house, building, and whatever it is, to make that search. If he is obstructing me, I can forcefully ingress or outgress that building. If there is a Badanaski lady, that means according to the custom, those ladies who are not come to the public without a Badana. Okay, in that case, I need to inform that lady or give a prior notice to that lady and to make an arrangement to set access for that particular lady only. And after that, I can make the search and seizure search. Under section 47, elaboration is there. Search for a gist. Search for a thing. A weapon of crime. I need to search. And I know that it is somewhere. I need to search. So there are two circumstances arise. One is within the jurisdiction of my police station. Another one is outside the jurisdiction of my police station. If it is within my jurisdiction, I can go directly to that place, make the search and seize of that weapon and all that things. There, in police language, it is says that you need to make a panchnama. That means a memo list has to be made. I entered to this place, I found out this particular weapon which is going to be used or which is used in the offense. Caesar report, Panchanama, whatever you can take. Caesar list. Mostly in the court we call it Caesar list. Everything need to be documented. Cannot be done like that. Why I have used here only I mentioned as an accused, but if you go to section 47, they in the procedure we find out a word in this etc. Those persons are come to around whom you are mentioning that persons are also come under that code. I mean, it is not like that. If a police officer is let after looking at a police officer as particular, that police officer previously you are a what service? Which service? Defense. So when you are in patrolling, if somebody looks at you and starts to run, what is your intuition? I do something. Same thing done with the police officers also. If you in the railway station, you saw a Indian starts to run, that Indian starts to run behind you because the content you don't have a ticket. So there is a doubt is created, or any for the preventive purpose also. If the police officer has a reasonable doubt, reasonable information is there that this particular person is there in that particular building, they can come under this search for the place under section 47. There is a word in etc. So without doubt, so all that whatever you are saying, they come under that particular. You enter to this get here there is 100 people are there. Everybody is not dharma, including me. I am not accusing you only, including me. We all those who are here, we are not dharma. Might be some accused are here. In that case, police can enter and search for them under section 47. So next one is if that particular article is outside the jurisdiction. In that case, under section 165, if it is inside the jurisdiction, it can be done by that particular police officer. It is within his jurisdiction. He has to go search that thing and seal that complete. He has to make a memo, seizure memo or seizure list. He has to make and produce it before the magistrate. Complete. If it is outside his jurisdiction, let a Hyderabad police has to search for a particular thing which is used as in a crime weapon in the Hyderabad, and that he get a tip that that particular thing is in the river. In that case, what happened? A person committed a offense in Hyderabad. He hide that offense weapon or article in Tirupati. Hyderabad police get a tip that particular article which is used in that particular offense or any other article which is associated with that offense is in Tirupati. In that case, how that search and seizure can be done? Not focused on that. They have to come to the local police station, take a permission, and as accordingly they can. You are saying local standard. Local standard is that you are saying local standard. Local standard is what is your authority to stand? So in that case, he has to come to the Tirupati police station, take the permission, and can make the search and seizure. Clear? Then, but the question is, the Hyderabad police thinks that if they take all this or have to go through all this procedure, that article can be replaced or it can be destroyed by the accused. In that case, then what I am asking, if there is a chance of that thing, if the police thinks that we can, if the police from the Hyderabad police find out that in that case, if police is not supporting or there is a chance of delay to recover that amount, that article, in that case, they can directly come to the seize that article, search that article and seize that article. And after seizing and searching for that article, they can go for the permission from the local police station and in your stop, if there is a circumstances like that, they can go to the local court. So this is the search without warrant. Yeah. Okay. Thank you and have a good day. In the auditorium. My class is over. You can come. Rashmi ma'am is also here. जूली मैम इज कमिंग जूली मैम आ रही है मूड कोर्ट के लिए अब अश्विनी मैम को आना है अश्विनी मैम को आना है उनका ही क्लास है क्योंकि फोर्थ आवर में ये साल लेंगे फोर्थ आवर में वो लेंगे आपका सेकंड साल लेंगे आपको आफ्टरनून लेंगे आगे अश्विनी अश्विनी they need to submit their memorial. They need to submit their memorial by test. Today also we will allow. Now we only in cause of that. One guy here, one guy there. No, even the yeah, the names will be changed here. He will be there. This person is there. Yes. Yeah, after we will not change. This is the final thing. If they won't, they let them participate. What Madam said, 10 will be the enough event to wait for. And next time they will come back. Now only there is no break for these guys. Unless and until this she is simply sitting there. Now another thing is like influencer told me one girl is standing outside. I told that girl she is not attending. He says within 10 class she is coming for signature. How he is very soon to these persons. Hello. Life should come from the where are you? This is Julie. Where are you? No, please. Principal sir, like you are standing outside. We didn't tell you. So you are lying. And actually you are coming to college, so you are going to go to you come and meet me. The principal sir said like she was there.
I call all the students to occupy your seats. I'll be starting the session soon. I call all the students to occupy your seats. Students, how many work also? Get into your class. Julie, Julie, yes. Those who are standing outside, get it. Why you raise this low? Movement. Yes. As requested by few of the students, today I would like to share the opportunities that you have after finishing your degree, and you will be seeing the opportunities that you missed till now. So no regrets, you can start fresh. Okay. Many of you have taken admission to this course to become a judicial officer and to become an advocate, and some of you have taken admission just for a degree sake and advocate. Both ஒரு விசிட்டிங் கார்டு இருந்தா அது ஒரு தனி மந்தா ஒரு gift. Okay. The third category, I discussed with that with regard to the third category and later that. Ready, madam? I agree. My father is a lawyer, my mother is an advocate, and so I want to become an advocate. So to continue the advocate office, okay, that is one thing. Today I may be expecting very true and true answers from you. True, true and honest. You can go with that. Please prepare for admission. Very much. Yes. So this is a very gentle interaction we will be having today because this is out of your syllabus. Okay, professional సంబంధించింది కాదు. ముందే చదువుకుంటుంటే వేరే రకంగా ఉండేది మీ పరిస్థితి. You all have taken. Here we have a combination of 3 years and 5 years. 3 years and 5 years. We have a combination. I have taken all the information from Google only. Okay. So it is not confined to only 3 years. You have taken admission to a law course. That's all. And so after completion of your degree, obviously you have to enroll as an advocate. Prior to that, a condition precedent is you need to qualify as exam conducted by bar. That is AIE. One is AIE, All India Bar Examination. Next, few of you may prepare for judiciary and become a judge or a magistrate. Judicial services. You have to prepare. Only with a law degree you can become a judge. So your admission is to Alkapati. You have many options actually, and you can choose the option which suits you, suits your attitude, temperament, etc. etc. That yes. Next is judicial services. The next is you can apply for public service commission. Okay. And next is competitive exams. AIE exam. If you appear for an AIE exam, definitely if you qualify, then you will be enrolled as an advocate. So here, the scope of the profession is vast. You can confine your practice, your profession to one specific field of your choice. Advocate అంటే అన్ని కేసులు తీసుకోవాలని లేదు. వచ్చిన కేసులన్నీ తీసుకోవాలని లేదు. You can acquire specialization skills in one specific field or an area. Like you can become a criminal lawyer. No criminal lawyer. దానికి తగినట్టుగా మీరు ఎక్విప్ చేసుకోవాలి. Next, civil lawyer. You can confine your profession only with civil cases. మనకి ఎందుకు అప్లై చేస్తే పోలీస్ స్టేషన్ అర్థాలు చేస్తే పోలీస్ స్టేషన్ అర్థమయ్యే వాళ్ళకి civil matters be confined. Okay, but here the trick is if you want to see money written in here, written in here, which is more money on everyday basis, day-to-day basis, you can take a criminal cases. Sarana, bail, cutting further bail, bail, civil cases, civil liability, okay, civil lawyer, okay. I tell you, okay, standard consumption amount, monthly standard 10,000 rupees రావాలి అనుకుంటే, it takes 5 years minimum 5 years to earn, to get 10,000 rupees as standard amount. You have to work hard. These are all the hard realities you need. Many of you already వచ్చేసింది మీకు. Okay. And next is, you can become IT lawyer, income tax. You can confine your profession dealing with only IT cases. That's all. Next, cyber crimes. చాలా ఎక్కువగా ఉంది. Okay. Let me finish up this slide. Next, you can become a legal advisor. Legal advisor to a company, to a corporate, or any establishment institution. Legal advisor. Okay. Next, you can become a document drafting lawyer. It is very rare nowadays. Very rare to see a lawyer who drafts very different. I mean, everything those days, the computerization రాకముందు advocates, document writers, వీళ్ళందరూ డ్రాఫ్ట్ చేసేవాళ్ళు అన్ని డాక్యుమెంట్స్. Next, you can become, this is competitive exams after that. Bank exams రాయొచ్చు. బ్యాంక్ మీరు ఆఫీసర్ చదవచ్చు through notification. Okay. ఇది చెప్తున్నారు అపాయింట్మెంట్స్ కూడా చూడండి. Okay. It is up to you to choose. Now I take 2 minutes break. Professor Julie wants to share something with you, and later on I will continue my discussion.
Very good morning to all of you. See, already we discussed regarding the football competition. Some doubts were there regarding the team members. The team members which we finalize is final only. Once again, we will see the team. If any clarification today, 2:30, you need to come and meet Thomas sir. Mohammed Faisal A, Mohan Das, Naveen S. First team. Once again, you can decide who can be speaker 1, speaker 2, and researcher. For example, if I am reading in an order, you can decide again I am telling who can be speaker 1, speaker 2, and researcher. And another thing, this month 10 is the last day to submit your memorial because 2 rounds are there. Memorial round is there, and April 10 is the last day to submit your memorial for petitioner side and for respondent side. Clear, right? Yes. Then Charishma, Kanuja, Mahidha, second team. Kimani, Maheshwari, Anushya. Then next team, Rega, Arya, Aravind. Next, Abhinesh, Bharat Shaini Satya. Next team Ramya Sri Shivani Satya SDK. Next team Sheikh Javed Nandita K. Babu Reddy. Then Madhuvadani Vinovardhani Hema Malini. Next team Humayun Sheikh Virendran Govil. Next team Cincy Wilson Minnie Davis Desher. Then P.M. Chandana Naveen Khanna P. Hariharan. Then Victor Tankar Vijay B. Kamal Selvan. Then Jyoti Rajula Vinay Jose. Then Yadu Krishnan Prasad Reddy Sai Sabhi. Then Manivannan Shanmuga Sundaram M. Venkata Subbareddy. Then S. Kiran Manish Mavasha. Then Villa Gaudam Raju Ashwini Narayanan Dinagar Babu. Then Bhuvaneshwari Krishna Yuva Sandhya Nishad Urusai. Satyavani C.V.S. Sharma and Darshana Sri. S. Karthik M. Kamal Selvan Yogeshwaran T. And the last team B. Venkata Harana Devan. And one more thing, after discussing with the management, today, after today evening, they will give you chance to register. So, if any person comes to register, 3 persons should be there. As a team only, you will present your moot court competition. Is it clear, Sharma? Okay. So, any doubts? If you are having any doubts, you can contact me, either me, because I am having class in the afternoon. Rashmi madam will be available here. Shimavastu sir. Okay. So, better 2:30 sir will be available. You can come and meet me. So, thank you. And the 10th is the last day. Yeah, either if any students are down here, please convey this message. Your team members is here, please convey the message. So your friends also please convey the message. Already we discussed this matter. Try this is a try I am discussing here. So 10th is the last day regarding submission of memorial, and the first round is memorial afterly according to the all the instructions in rules and regulations clearly mentioned. According to that only you need to prepare your memorial. Thank you.
Yes. Yes. Let us continue. The next is after completion of your Ll.B, you can continue your higher education. You can take admission to Ll.M. Okay. So once you finish your Ll.M, you can opt for academics. If you are not interested in profession, practice and all, you have another option to go for teaching. Teaching your town, we have teaching skills, abilities, confidence, you can, you can. So you can pursue Ll.M and do research, legal research, PhD, and appear for national eligibility test to get employment, to get appointment as an assistant professor, associate, or professor in universities. Okay, so you have an option of going to teaching. Even if you practice, you can go for teaching to a limit of 3 hours per day. So you cannot both practice as well as teach. Okay. Then you can get intense or 1 year level And next, the next one is okay. Letter is white of the cavity, no. The next is media. You can enter into sector, media sector. You can become a correspondent, legal correspondent. Okay. Uh, Nationwide newspaper system for each every segment. They have a special correspondent. Special correspondent. So, legal correspondent from the issue, and you can involve in legal journalism and writing, critic. You can be a critic of law. Okay, and then you can work with an NGO. You can assist an NGO. You can become a part of an NGO. Okay, తర్వాత bills breakup. Bill. Next, Ll.B. What is this Ll.B? Legal process outsourcing. Legal process outsourcing. This is just 1 year course. Few years back, I advised students also, but I don't know whether the academic level happened to someone university. When you are in fourth year, the last year, when you are in final year, you can simultaneously take admission to this course. Legal process outsourcing. By the time you finish this course, the LPO course is also get finished. So, what data analysis is that? First, business units. LPO, legal processing outsourcing. Okay, legal process outsourcing. That is BPO and business process outsourcing. For legal field, LPO. Okay. And next, you can do certain diploma courses. PG diploma courses after your LLB, which adds weightage to your LLB. In our previous slide, you have seen you can confine your practice to one specific field like criminal, civil, IT, etc., 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 right? The same. If you do certain PG diploma courses, it adds weightage to your degree, your qualification. You can improve your resume, okay, credentials, and what are the courses that are available in different fields, okay, different laws. Applications are day one from first semester to last semester. No paper is fixed. No law paper is fixed. ఇది చాలా సింపుల్ మనకే రాదు అనుకోండి అదే మీకు పనికి చూపించారు ఓకేనా అండ్ లేబర్ లా if you select diploma courses in labor law then you will be selected as a labor officer. Labor officer. So diploma course certificate with labor law that adds weightage to your LLB degree. You will be observed as a labor officer. And next, taxation law. You can become an IT consultant. Next, IPR. Intellectual property rights. Intellectual property rights law. IPR law. Okay. And you can become even a patent officer also that gives more weightage. Patent officer అనేది ఒక మంచి prestigious position. You have to work. I know law చేస్తామే మరి క్లయింట్స్ రావట్లేదే మాత్రమే వెతుక్కోవాల్సి వస్తుంది ఒక క్లయింట్ వచ్చే క్లయింట్ లేకపోతే పట్టిస్తామా అని చూసుకోవాలి. You have many other options available. Okay, so don't feel that. Don't feel low if you are not flourished in one area. You can opt for another area. Okay, sad, depression, and cyber law. You can do the courses, different courses, cyber criminal, data security. Okay, yes, and criminology and criminology, which you have now. This semester you have criminology and victimology. Earlier it was criminology and penology that has the nomenclature is changed to penology and criminology now. And so you can become an analyst. Next, family law, diploma courses. You can do family counseling. You can start a family counseling. You can be a counselor, registered family counselor. Okay, recognized family counselor. Next, environmental law. If you do a diploma course in environmental law, then you can be an analyst. Environmental analyst. Our India on the exposure like amount of money. US like environmental law. Okay. And next, arbitration and dispute resolution. ADR. So, no subject is placed. Each and every subject is equally placed. There is no difference. Many universities are offering. So, it is you to search for the universities. Forensic also. Forensic. I have not mentioned forensic also. There are litigation advocates when I was in Navy, I was shocked because that was the first time to see a board, name board, we deal with litigation only. It is specifically mentioned on the board. Advocate, a litigant advocate, we take up only litigation cases. I never litigated on it. We assist don't have yeah, we have options there. And now, whether we have to confine our living only in India or we can go to abroad is another question. My advice is don't go to abroad. Because we will be missing Bharat. We will be missing the family connections, family emotions, etc. etc. Respect that. Here we can respect. See, only if you give respect, you will be respected. This is one principle. Only for minor and young, we need to go to abroad. Do one thing. Okay. As usual, other president stay there for 3 or 4 months and stay in India for the remaining period. Huh? For more respect. Our dad abroad. Foreign with advocates. Huh? Yes, is for the very okay. And so, even if you want to go to abroad, then you can on satisfying certain conditions specified by the specific university. Our university aim to the our university aim to spread this to the Darwinian testimony. You can continue your either higher studies or you can be placed there. Okay, like you can have it as law firms, solicitor firms there. That's what on satisfying certain criteria you can be placed. Then immigration law. Even sometimes you will get an opportunity in embassy also. Embassy. Embassy and okay. So at least now you just introspect how much opportunities you have missed and what are all the opportunities you are left with. Basing on that, you concentrate, you develop yourself, you can improve your profession. Okay, now this is What is that? Ll.B is sufficient. There are many students. Even last year also, 2, 3 students have come for recommendation. You get PG and higher studies under Sri or universities. అక్కడ చేస్తామంటే అక్కడ అబ్జర్వ్ చేస్తున్నారు chances are. Okay, so with this we have seen what are the options that are available to an Ll.B graduate. 3 years or 5 years. Have faith in yes. ఎవరికి నమ్మకాలు ఉండవు ఇక్కడ నీకే ఉంటారు. ఓకే జాక్ చెప్తావా డైరెక్ట్ అదే వాళ్ళు ఎగ్జామ్ రాస్తారు పబ్లిక్ సర్వీస్ కమిషన్ లో ఇది రాలేదా చెప్తారు ఎవ్రీవేర్ ప్రతి ఒక్క ఆర్గనైజేషన్ ఇన్స్టిట్యూషన్ అయినా సరే ఒక జాబ్ వస్తుందని కాదు. Okay, so sometimes the same job person play the role of paralegal at budding stage. And so one important thing I need to tell you is once you enter your profession, practice environment, you must show respect to your senior colleagues. Not only your senior colleagues, but the one who is senior or both your senior advocates. Okay? వాళ్ళు వచ్చినారంటే కోరుకోండి ఎంటర్ అయ్యారు అంటే మీ వాళ్ళు మీరు కాల్ పెట్టి కావాల్సిన కూర్చోండి. You have to get up and you should give seat to them. That's all. You know, I am older than him. He is a very young child. Though he may be a senior, he is very young at age. And age is not a criteria. Even if you are a 70 or 80-year-old man practicing law, and you are a junior. Remember, junior-senior relationship exists. In age in college, no, nothing. Because seniority is given only on period of practice, and additional thing is knowledge, expertise. Only if you show interest, only if you show respect, if you respect the person, senior, he will correct you when you are wrong. He will guide you, he will explain you how to we have a mother you will stay there. Remember? Okay? So, with this, I will be concluding my lectures. And meet you soon. Okay? Do you need any revision also? Only have to see the pattern, examination pattern. You don't have internals on professional things, right? There is a chemical analysis. Oh, I thought this is last year. For a few days I took last year. So, who's next year? Sridhar.
Raymond. Installments. Yes, I can. Next. Fourth is.
Yes, sir. First నుంచి ఇక్కడ నుంచి చెప్పేసారు.
Thanks. What corporate? Who you Yeah, please. Yeah, please. No. One question will arise. For general, we don't have this subject. For honors only, yes. Right. For case law, on the case law comes with respect to the company, you say, I am general, I didn't read that subject, so I don't want the case law. Is there anything lawyers to one subject you can tell to claim general and one subject I am on the case law right? If you want to practice on the corporate side, entire scenario has been changed now. Corporate side போனோம்னா companies கிடையாது. Invariably, insolvency and bankruptcy code is there. Case law వచ్చింది చదువుకోవాలా. Previous class, your madam was telling practical applicability of lawyers. Theory தெரியாது உங்களுக்கு. Practice என்ன தெரியும்? Right? So general people, listen. Every day is a learning day for you. If you don't learn today, you are dead for today. That's it. Learn. Right? There is no such thing that only subjects will vary for what is called examination purpose వరకే subjects ఉండదు. మిగతా అన్ని subjects ఉంటాయి. Right? Yesterday we have seen. Now you will tell general people if you want to go, you can go. You don't have the subject. Right? Right. Don't think this is a profession. It needs lot of what is called reading, understanding, assimilating. So many things will come. Sharma, college will now. Right, yeah, please. I know that you are all feeling hungry. It's the back end of this afternoon. but there is no option left for you till 16. Whether you like the class, whether you like me or not, we have to sit in the class. And what is our program? You get a class. Everyone understand? Okay? Now, what is the idea? What is it? Right. What is it? Right. Now, please listen. So yesterday we have seen these three types of persons will come and file a petition before adjudicating authority, national company law tribunal. Right. Once your application has been admitted, from the date of admission of your application, moratorium will come into existence. Moratorium varo. Right. Moratorium, be honest, right. Moratorium will come. Right. Now, moratorium, what happens is, entire company's operations will be handed over to professional, interim professional. Ante, the main thing is you cannot dissolve the company here. You have to run the company. Who has to run the company? Normally, who will run the company? Board of directors will run the company. The entire thing ఏంటంటే కంపెనీ మూసేయమని చెప్పి కాదు కంపెనీ క్లోజ్ పని పోవడం కలియాలి. The only thing is you are coming and solving the dispute. So you have to make the company run. While running the company, you have to solve all the what is called issues. And once the company is in the right track, again you have to hand over the company to the board of directors once again. మళ్ళీ మీరు ఏం చేయాలి కంపెనీని వాళ్ళకి ఇచ్చేసేయాలి మీరు కంపెనీని అమ్మడానికి కుదరదు ద మెయిన్ థింగ్ ఈజ్ liquidation is separate stage. This is first stage. Corporate insolvency resolution process is the first stage. Main thing என்ன எடிட் கம்பெனி எடுப்பான்னா ஒரு ப்ராப்ளம் இருந்தது இந்த ப்ராப்ளம் சால்வ் பண்ணாம என்ன பண்ணுவாங்க தெரியும் இந்த கம்பெனியை அவங்க கையில கொடுத்துட்டு இவங்க போயிடுவாங்க. That is the main thing. முடியல அதனால என்ன பண்ணணும் தெரியும் லிக்விடேஷனுக்கு போகணும். First we have to solve issues. If you are unable to solve issues, then you have to get the liquidation order. Right. So, moratorium will come, interim resolution professional will come over the company, he will take charge of the company. The board of directors powers will be temporarily kept in abeyance. Abeyance means not suspended. Time being, they will come to a halt by operation of law, by virtue of law. Separate board of directors order postponed in the Panna. Once moratorium comes, automatically what happens? Your power comes in abeyance. That's it. The power say undadu. Yaar powers irukadu? Board of directors don't have powers. Right. Next, he has to receive all the he has to constitute a committee of creditors, right? Creditors constitute பண்ணனும் ஏன் தெரியுமா? They are the persons who gave money to the company. Without their permission, you cannot do anything. We have to constitute committee of creditors. You have to monitor the assets of the corporate debtor and manage its operations until a resolution professional is appointed by the committee of creditors. Whenever you are making an application, you mention a name of an interim resolution professional. He will be working till the committee of creditors appoint a normal resolution professional. He may be replaced or the same person may be appointed as a final resolution professional. Right. Now he has to take the information collected with the information utility. He will quote information that is NESDL. they will be having all your information. For example, if you take loan from your bank, personal loan from any bank, automatically your information will be taken over by the information utilities. They will give you the message. The bank has told that you have taken money from the bank. Your bank is a creditor or corporate at all. Please kindly confirm. Immediately you have to confirm that yes, I have taken the money. This information will be stored with information utilities. Right. He has to take control and the custody of any asset over which the corporate does not has ownership rights as recorded in the balance sheet. You are taking the balance sheet. You know the division of balance sheet. Liabilities, assets. So, whatever has been mentioned in the balance sheet, you have to take over the balance sheet. So, you have to take the ownership rights as recorded in the balance sheet of the corporate debtor or with information ability or depository of securities, industrial, CDSL, or any other registry that records the ownership of assets, including assets over which the corporate debtor has ownership rights, which may be located in a foreign country also. Company की the person is taking over all the assets as well as liabilities. The interim resolution profession is taking all the assets of the company, all the liabilities of the company. Assets may be located in India or outside India, liabilities inside India or outside. எல்லாமே எடுக்கணும். ஏன் தெரியுமா company ஓட financial structure you have to know. How you are going to know the financial structure? By reading the balance sheet. Balance sheet பார்த்தா கம்பெனிக்கு எவ்வளவு ஆஸ்தி இருக்கு எவ்வளவு கடன் இருக்குன்னு சொல்லி balance sheet you have to read. Right. Next one, assets that may or may not be in possession of the corporate debtor. That means if the corporate debtor has mortgages of assets, mortgage assets, you know ownership. Ownership ఏమవుతుంది ఇక్కడ legal ownership, legal rights will be there. That ownership will be to the corporate debtor. Possession of assets with mortgage. Mortgage చేసినప్పుడు ఏమవుతుంది రైట్స్ మీ దగ్గర ఉంటుంది ప్రాపర్టీ ఎవరి దగ్గర ఉంటుంది మార్గేజీ దగ్గర ఉంటుంది దట్ ఇన్ఫర్మేషన్ ఆల్సో యు హావ్ టు టేక్ ఆ ఇన్ఫర్మేషన్ కూడా యు హావ్ టు టేక్ వై యు హావ్ టు రికార్డ్ ఆల్ ద క్లెయిమ్స్ పొజిషన్ ఇస్ దేర్ రియల్ పొజిషన్ లీగల్ పొజిషన్ సో మెనీ థింగ్స్ నెక్స్ట్ వన్ tangible assets అంటే which can be yes such and seen company tangible assets இருக்கும் அதோட என்ன assets இருக்கும் intangible கூட இருக்கும் intangible என்ன goodwill intangible assets also even intangible assets also carry value. You know the meaning of intangible goodwill ఉంటుంది for example this is the college. When college starts, we started a tea shop there. అప్పుడు అప్పుడు యాభై టీ షాప్ ఇప్పుడు நிறைய பேர் வரா so tea shop cost 50,000 you sell it for 3 lakhs why 2,50,000 is goodwill that is intangible. So companies have tangible assets, he has to take over intangible assets, he has to take over. Then securities including shares. Shares also he has to take. Held in any subsidiary of the corporate debtor. Subsidiary. Yes, what subsidiary is? In which subject have you learned the subsidiary? International trade law. Subsidiary, holding and subsidiary companies. Companies subsidiary means three types you can hold subsidiary companies. Three majority of directors, majority of shares having control. Three ways you can make another company as a subsidiary. Yes. ఏమో క్లాస్ వస్తారని చూస్తా ఉంటారు మైండ్ లో పోతా ఉంటారు అర్థం కావట్లా fag end of your subjects. That's what I'm telling. There is no fight, nobody will come to class. Because to pay the fine, you are coming, you are sitting, right? Right. Is anything going into your minds? Or going into your ears? కాదులు పోతా మైండ్ పోతా కాదులు పోతా ఇంటి పోయాం మైండ్ పోతా మైండ్ వచ్చినాం అండర్స్టాండ్ నో big arbitration case will not speak. The client will give you this much booklet 10,000 pages. You have to argue tomorrow in high court next day. You read 10,000 pages. 10,000 pages arbitration agreement, technical agreements, how you are going to read and prepare the case. చెప్పిన అర్థమైందా పెద్ద ఇంత కేసు ఇస్తాను కట్టిస్తాను చేసి రేపు హైకోర్టులో స్టే చేయమన్నాడు రాత్రంతా కూర్చొని చదివినా 10 పేజీలు పోదు then how you are going to assimilate. That is the beauty of the law. 10,000 పేజీ అమౌంట్ వాడు ఎంత రాయాలని పడికి వాడాం చిన్న టెక్నిక్ అనుకో ఫస్ట్ we have to go to what is called procedural lapses. Procedural lapses we have to go first. Then we have to go substantive lapses. Then third one is administrative law, principles of natural justice. First we have to prepare the case and file the case. And then how it comes by practice. Right? This is how we have to practice in the law. Next one is securities including shares held in subsidiary companies holding and subsidiary company. That means these companies having 2-3 companies will be there under the umbrella of this company. This company becomes holding company, that company becomes subsidiary company. Even it has to take information from subsidiary companies also. Subsidiary companies put on the information you have to procure. Then financial instruments, you know, shares, debentures. Debentures is also a financial instrument. Then insurance policies. The company can have a policy and name the law. So whatever be the amounts, they have to get the information first. Why? To resolve the dispute. The entire thing is they have to pay to the creditors. ఇంకా డబ్బులు కావాలి ఏం చేయాలి కంపెనీ అసెట్స్ తీసుకోవాలి కంపెనీస్ కి யாராவது காசு கொடுத்ததுல லிஸ்ட் எடுக்கணும் அவங்களுக்கெல்லாம் ஃபோன் பண்ணி the company you have to pay the amount, please pay the amount. You have to take all the amount from the companies to pay to the financial creditors, to pay to the operational creditors, to pay to the corporate applicant. ಯಾರು ಕಾಸು ಕೊಟ್ಟಲ್ಲ ಪೇ ಮಾಡೋದನ್ನ ವಸೂಲ್ ಮಾಡಬೇಕು ಫಸ್ಟ್. You are taking. Next one is assets subject to determination of ownership by the court of authority. Court level case irundadu property varana and information gather for example companies having land, there is a dispute between company and some other person, that is in the court, we have to pay that information also, right, to perform such other duties as may be specified by the board. Board means Insolvency and Bankruptcy Board of India. ఇంకేదైనా ఉన్నా కూడా మీరు ఏం చేయాలి తీసుకోవాలి. Let us recapitulate Once you file an application before the adjudicating authority, moratorium will come. Moratorium will come into existence. Previous proceedings stay. Past proceedings, you cannot file any case before any institution, authority, tribunal. అయిపోయింది కేసు ఫైల్ பண்ண முடியாது. இப்போ எல்லாம் ஸ்டே ஆர்டர் இருக்கு. இப்போ நெக்ஸ்ட் என்ன பண்ணணும்? இன்டரிம் ப்ரொசீஜர் என்ன பண்ணுவா? கம்பெனியோட ப்ராப்பர்ட்டிஸ் எல்லாம் கூட லிஸ்ட் அவுட் எடுக்கும். ஏன்னா அவங்க பே பண்ணணும். Then what he has to do? Take all the information from the information utility. He has to take all this. Please పెట్టుకున్నాడు ఇంకా. పెట్టుకున్న తర్వాత ఇన్ఫర్మేషన్ ఉంది. ఇవన్నీ ఎవరు చేస్తారు అంటే ఇంటరిమ్ రెజల్యూషన్ ప్రొఫెషనల్ ఒక వ్యక్తి చేస్తాడు. అన్ని చేసిన తర్వాత నెక్స్ట్ ఇంపార్టెంట్ థింగ్ ఈజ్ he has to appoint committee of creditors. కమిటీని అపాయింట్ చేయాలి. ఏ అపాయింట్ பண்ணணும்னா within 180 days if he is unable to complete the corporate insolvency resolution process, he has to take permission from the committee of creditors. Next step ఏం చేయాలి? He has to constitute a committee of creditors. Next, constitution of committee of creditors. So interim resolution professional specifically provides that he shall collect all information relating to the assets, finances and operations of the corporate debtor for determining the financial position of the corporate debtor as well as receive and collect all claims also. It also prescribes the constitution of committee of creditors as one of the duties of interim resolution professional. ఈ సబ్జెక్ట్ ఇంతగా అయిపోలేదు. నెక్స్ట్ వస్తుంది ఫాస్ట్ ట్రాక్ ఇన్సాల్వెన్సీ ప్రాసెస్ విల్ కమ్, లిక్విడేషన్ విల్ కమ్, bankruptcy of individuals and partnership will come. So at any point of time they will ask you any questions. Yesterday when I have switched out the fan, many people left the question bank here only. Question banks are here வச்சுட்டு இதுக்கு அவசரம் வேற அவசரம் இல்ல. உங்களுக்கெல்லாம் question bank எல்லாம் தேவை இல்ல. Your brain itself is a question bank. Why? Whatever they give, I will write something. எல்லாம் கலந்து எக்ஸாம் எழுதிட்டு ஃபர்ஸ்ட் செமஸ்டர் கான்ட்ராக்ட்ஸ், கம்பெனி லா, அப்புறம் வந்து ஃபேமிலி லா, ஃபேமிலி ரைட் கூட இருக்கு. ஃபேமிலி ரைட் அப்புறம் arbitration, you write IPC, you write constitution, everything under insolvency and bankruptcy law. அது எழுதும் போது ப்ரொஃபசர் புரியாத மாதிரி எழுதுவோம். புரிந்தா புரியலன்னு அர்த்தம். ஏதாவது எழுதணும்னு சொல்லி 32 மார்க் வந்து பாஸ் ஆக சான்சஸ் இருக்கு. நீங்க அப்படியே எழுதி போறோம். Don't write like this, right? Look at my apartment. Right? Ah, Chopa. Still in the last hour. Right? You paper not again kavale. Right? Till now you have understand. Till now you have understood the steps. This is the procedure law. ఒకటి తర్వాత ఒకటి ఏంటి అని తెలుస్తుంది. Next one is interim resolution professional shall after collation of claims means whoever is having claims against the company, claims alone paper la public announcement கொடுத்து company கிட்ட இருந்து யாராவது காசு வேணும்னா நீங்க வாங்கணும்னு சொல்லி நோட்டீஸ் கொடுக்கும். அந்த நோட்டீஸ் நீங்க அப்போ வரலன்னு நினைச்சுக்கோங்க. company process you cannot subsequently அப்புறம் வர முடியாது. Your claims cannot be considered later. First you have to come and submit your claims, right? Then he will prepare the financial position of the corporate debtor and the constitution and committee of creditors, right? ఇప్పుడు ఎవరున్నారు ఇక్కడ? committee of creditors is there. இப்போ என்ன பண்ணணும்? ஒரு flag ரெடி பண்ணணும். என்னன்னா resolution flag. இந்த ప్లాన్ ప్రకారం మనం పోనా ఈ ప్రాబ్లం మనం ఏం చేయగలమో సాల్వ్ చేయగలము. Do not approve, prepare one plan. ఎవరితో ప్లాన్ ప్రిపేర్ చేయాలి అంటే కమిటీ ఆఫ్ లీడర్స్ కూర్చొని ఒక ప్లాన్ రెడీ చేయాలి. ఈ ప్లాన్ ప్రకారం మనం రెడీ చేస్తే మిగతా మనం ప్రాబ్లమ్ సాల్వ్ చేసుకోవచ్చని. అగైన్ దిస్ ప్లాన్ హ్యాస్ టు బి అప్రూవ్డ్ బై ది adjudicating authority. Once again should be approved by the adjudicating authorities. For approve panano, right? Approval of resolution plan by the committee. The code has provided the committee with exclusive access negotiations, right? The committee of creditors will examine the resolution plan. The committee of creditors will examine the resolution plan. Right. The committee shall evaluate the resolution plans as per evaluation matrix. Ante it is feasible of ROI idiots only evaluate Parvana committee of creditors will evaluate. Record its deliberations on the feasibility and viability of each resolution plan. Is it possible or not? They will evaluate. Who will evaluate? Committee of creditors will evaluate. Then vote on all resolution plans simultaneously. They will vote on each resolution. Yes. Now we see where only one resolution plan is put to vote, it should be considered approved if it receives requisite votes. There are plans now if the plan is only one, it is enough. It shall be considered approved if it receives the requisite votes. Sunday. Question చదివేదా నీకు లేదా ఇప్పుడే చెప్తున్నా yes no it no there is no such subject that is not in credits or the subject is not important. Very good, that's the answer of the lawyer. The subject ఉందా எனக்கு subject இல்ல தெரியாது அவ்வளவுதான் finish. Okay. Great lawyers. Okay. So you can manipulate the judging take orders, sir. So you want to be a good lawyer or a great lawyer? Greatest lawyer. What I am trying to say, good lawyers will know the law, great lawyers will know the judges. Yes. So you can straight away go to judge, sir, this is the case. I am taking this much space. I pay you this much space. You will make the order. Subsequently, it gives you the order. You know for what? Go to jail. And the shortcuts, we don't go into everything is only shortcuts, like very short. Your life is short, everything is short only. అర్థమైందా? ఇప్పుడు చెప్పు సబ్జెక్ట్ ఉందా లేదా నీకు? వాళ్ళు లేదన్నా జనరల్ కాల్స్ లోన్ ఆఫీసర్ కంపెనీ కేసు నిన్న చూడండి కాలేజ్ పడికిలా అదానికి తెలియాలి కంపెనీ అభివృద్ధి అయిపోయింది దరిష్ణ కంపెనీ యాక్ట్ అవుట్ తెలుసా రైట్ ఉదయం ఇండియా ఉదయం అబ్బాయి ఉదయం రైట్ కర్పగలాయ అంటేనా కర్పగలాయ రైట్ sleeping. No, sleep. After having your lunch, you can sleep. Before you lunch, lunch still one slide is there. Let me complete and right. Right. Now, when two or more resolution plans are put towards simultaneously, the resolution plan which is receiving highest votes, it will be approved. When two or more resolution plans receive equal votes, but not less than a requisite force, the committee shall approve any one of them by using typebreaker formula. Formula use பண்ணி அத approve பண்ணலாம். If approve ஆனானா we can go with further process. The plan approve பண்ணி நான் approve பண்ணனும். Committee of leader approve பண்ணனும். திருப்பியும் NCLT has to approve. Approve it can make modifications. If the NCLT don't approve this plan, we have to go for liquidation. And the plan approve பண்ணி நீ follow பண்ணலனாலும் and the plan approve பண்ணலனாலும் liquidation we have to go. Right. Where none of the plan resolution plan receives the requisite votes, the committee shall again vote on the resolution. Again voting is ultimately the committee of printouts decide the resolution plan. The resolution professional shall endeavor to submit the resolution plan approved by the committee to the adjudicating authority at least 15 days before the maximum period for completion of corporate insolvency resolution process. So again it has been given to the NCLT for approval. Right? புரிந்த எல்லாருக்கும் இதெல்லாம் procedure apply ஆயிட்டா இந்த எக்ஸாம்ல this procedure you have to write. Right? Remaining question. Right. Very good. நாளைக்கு